that there was a request for an extension on the limits within which the accused here have to remain, that is 30 kilometres of the court, and it was asked that that be extended to 60 kilometres, the purpose of that being that if they're here for some time, they're within reach, obviously, here of both Amsterdam and Rotterdam. That might very well be a matter that needs to be negotiated with the host state. It is the view of both the Ruto defence and, may I say, also the Sang defence on this particular subject that we would, as a matter of preference, if we may be permitted to express that preference, prefer hearings that were in chunks, as it were, of 3 to 4 weeks at a time. So it would be Kenya 1 for 3 or 4 weeks, followed by Kenya 2 for 3 or 4 weeks.
We also pray that a provision be made, if possible, by the Chamber for an option to conduct the presence of the accused for trial through video link. And may I qualify by saying that my client wishes and desires to be present and will only seek it in exceptional circumstances if that provision is secured.
Mr. Ruto has asked the Chamber to consider providing the defense with more time to prepare its case. The Chamber would like now to hear the submission of the parties on the trial start date in light of the current state of disclosure. The current state of disclosure, as understood by this Chamber, is that the identities of between 5 to 7 witnesses out of 41 witnesses have still not been disclosed to the defense.
Madam President and the Honours, we pray that you do find us to have deserved the exercise of your powers to defer the date from when the trial should commence, and that the prosecution be constrained to make full and complete disclosure in good time for us to be able to prepare ourselves for the defense.
When you say you need time, more time to prepare, can you suggest approximately how much time you need?
Madam President, I would say on our part that we would request for a period of up to 4 months from the last date of a definite disclosure on the part of the prosecution. Madam President, it is our argument that the case that the prosecution proposes to advance in the full trial has shifted, and I can illustrate on only 3 items out of the many items we've seen. The first one, Madam President and Your Honours, would be, for instance, that in the initial case that they presented at the confirmation stage, the prosecution's argument was that the aggressors took the shape and the vehicle of an outfit called ODM, a political party. However, in the course of studying the disclosure of the witness testimonies and their pretrial brief, it is clear that the aggressor has shifted into an outfit called the Kalenjin as an entity.
The emphasis on significant parts, or I say the emphasis on parts of the case, has shifted. And the focus that was, in fact, on the events of December and January and the month or so immediately preceding it, of 2007-8, is now, in fact, taking in events in early 2007, 2006, and back into 2005. 2002.
There hasn't been shifting sands in this case at all. And defense counsel know that full well. Prior to the confirmation hearing, defense counsel received redacted versions of some of the most crucial witnesses of the prosecution. And these witnesses still remain crucial witnesses. They're crux witnesses for the prosecution. And within these statements, even redacted, This whole question regarding period of time or events that occurred before the post-electoral violence come out repeatedly. And there's one explanation for that. It's because they're intimately related to what happened in 2008. But defense counsel know full well that the events that occurred in 2005 during the referendum in Kenya are intimately related to the events that occurred afterwards during the post-electoral violence.